We can move on to the third question, which is itself quite controversial. There have been views that the Vice President's resignation will result in the cancellation or pre-termination of the impeachment trial. And I think those views are informed by past impeachment practice. The resignation of President Estrada resulted in the termination of that impeachment court, the resignation of Ombudsman Mercedes Gutierrez, Andy Bautista resulted in trial not proceeding, but we also have quite recent practice from the United States where because of the disqualification consequence or question, their U.S. Senate decided explicitly to push through with trial even if President Trump had already resigned by that time. So your views on this question?
This one is clearer. There are two consequences of there are two issues which is impeachment court will resolve. Number one, the issue of dismissal from office, and second, perpetual disqualification from holding public office. The resignation will make the first question academic. But the second issue is valid, perpetual disqualification from holding office, which will justify or which will provide basis for the continued trial in order that a decision can be rendered on the second issue. This issue, however, would have to be addressed to the impeachment court. In other words, it becomes a political issue and question whether or not political in the sense of politics, whether or not the impeachment court will continue and continue to hear the case in order to rule on the second issue, which is perpetual disqualification. In the past, the impeachment court simply said, enough, ayaw na namin, uwi na kami. So wala na. So theoretically, the impeachment court can continue and decide on the second issue. But that's in theory.
Senator President Dillon, before I go to the other panelists, I think your experience here would be very valuable since you're the only one in this room who has decided an impeachment trial, especially the one in 2001, where the Senate decided to terminate the trial once President Estrada stepped down from office. Would you be able to share to us the reasons why the Senate decided to pre-terminate the trial instead of continuing to that question of disqualification?
Well, this is the impeachment trial for President Estrada.
Yes, the 2001 impeachment.
Well, the EDSA DOS made it academic. Theoretically, we could have continued with the impeachment court, in theory. But given the political situation at that time, I don't think it made sense for us to continue the impeachment court. We could have argued that the impeachment court should continue to exist to tackle the second issue, but we, under the circumstances then, we said no more, enough.
Probably highlighting also the very political character of the exercise. Thank you, Senate President Dillon. Our other panelists, would they like to weigh in on this question? Commissioner Sarmiento and then Justice Carpio Morales.
I don't think it will affect the impeachment trial, the resignation, or a preemptive move on the part of the impeachable officer. Remember that under the Constitution, the Senate has the sole power to try and decide. In other words, it's up to the Senate. It's a political question. And one Supreme Court decision said, because of that sole power, it's hands off for us to interfere. It's purely a political question on the part of the Senate.
Thank you.
The Supreme Court cannot compel the impeachment court to continue being in session and try the second issue, which is perpetual disqualification.
Thank you, Commissioner Sarmiento and Senate President Dillon. Justice Carpio Morales, your views, please.
The question presumes that the resignation is made when trial has already started. Because if not, like the case of Andy Bautista and Mercedes Gutierrez, they were scot-free because I share the consensus that resignation when trial has started would not necessarily call for the dismissal of the articles of impeachment, because as intimated by Senator Drilon, impeachment is not for the protection of the respondent. It's for the prevention of abuses, continuous abuses, and for the protection of the public from being the subject of, call it corruption, bribery, high crimes, although high crimes defies complete definition. Thank you.
Thank you. Prof. Gwen and Prof. Ted, your views, please.
I agree. That particular question is again addressed to the Senate. So the Senate may decide to continue with the trial even though the impeachable officer or the impeached officer, so long as trial has already commenced, even if that official has already resigned. I think even for other public officials and employees, if there's an administrative case that's already pending, it will not be dropped just as a result of a resignation.
Thank you, Prof. Ted.
Concur.
I just clarify the administrative aspect of the case. An employee or official may resign if he or she wishes to, but if the employee or official resigns to jump the guns, in other words, aware of the impending filing of an administrative case, even if an administrative case has not been filed, he can still be within the jurisdiction, administrative jurisdiction of whoever is in charge of him or her.
That's a very important.
Just in theory, even if the impeachment court has not been constituted, even if the respondent has resigned, in my view, the impeachment court can still be convened for the purpose of the second issue, perpetual disqualification, because that's jurisdictional, that's within the power of the impeachment court, and therefore it is not academic by the resignation of the respondent before or during or after the trial.
Justice
How
Pepe
come,
Morales.
yes, Senator Drilon, how come you did not carry out that view when you were still an incumbent during?
Because the reality is, after undergoing that trial, it is so tiring that we don't want anymore, to do it. Having sessions morning and afternoon is not easy, especially,
Then let's have senators who are young so that they'll not be enervated.
That's why I'm not running anymore.
As a 10-year-old political nerd, then Senate President Wang, that was my political awakening, that impeachment trial in 2001. So I think for the information of our audience, the reason why this was brought up was it keeps getting raised in media interviews concerning what happens, can she avoid disqualification? Can the Vice President avoid disqualification if she just resigns? Because the impeachment trial would not proceed anymore. And I think there's some consensus here that there is a second consequence to impeachment, which is not just removal, but also disqualification from office. And a unique feature of that is that unlike any other penalty in law, that disqualification from office is actually not pardonable. So it's a very high penalty that the Senate can impose as representatives. Professor Pe.
I just wanted to say that I'm glad that we're using the word consequence rather than penalty, because in criminal law, a perpetual disqualification is an accessory penalty, but in impeachment, it's not considered as an accessory penalty. It's a consequence of a conviction. So, as Senate President Drilon has pointed out, there are two consequences: removal and disqualification. So while the resignation may actually preempt the removal should the conviction happen, the perpetual disqualification remains a live and pending issue. And so should that happen, it should not be treated simply as an accessory to the main penalty or consequence. That's why I don't want to use the word penalty, because it shouldn't be used. Unfortunately, we use the word conviction, which tends to mislead, because if we're thinking criminal law terms, conviction carries a penalty. But it does carry the two consequences, which are separate and distinct. The second point I'd like to make is because carrying out the trial despite resignation of an impeached public official just to determine the disqualification is consistent with the purpose of impeachment, to ensure accountability, because otherwise mootness will just simply sweep that down the road, right? It will just remove every attempt to make a public official accountable. The public official evades the removal and also evades the disqualification, while impeachment really is the constitutional last resort for as far as these officials are concerned. The offenses are so grave as to merit impeachment as a way of removing them, and therefore we cannot just simply say, by rendering it moot by resignation, even the aspect of whether this person could ever be allowed to hold public office would simply be swept away. So I would support that consensus, but would want to point it out that because of the consequence of just using mootness, we really should disabuse, right, the public of that particular consequence, that it is simply an accessory to removal. It is not. These are two separate and distinct consequences.
The principal consequence of that